Hello and welcome to our newest training resource on strategic litigation designed for professionals working with destitute EU migrants. This is a series of 6 training modules on strategic litigation in EU free movement cases, which is designed for professionals working to promote and protect the rights of destitute mobile EU citizens. However, it will also hopefully be of wider use to anyone working on EU free movement rights or even other areas of EU law. Each module focuses on a particular topic. This first module will provide an introduction to strategic litigation. The second module gives an overview of how member states engage in measures which restrict EU free movement rights and sets the background for the subsequent modules. The second module also provides a list of useful resources, including a brief introduction to Your Europe Advice, the EU's free online legal advice service. The third module will address judicial remedies and focuses on how to get the EU Court of Justice involved. The fourth module will look at alternative dispute resolution, and in particular the functions of Solvit, the EU's problem-solving network. The fifth module will discuss how to make a complaint to the European Commission. The sixth module will be devoted to the submission of a petition before the European Parliament. In this first module, we will look at what we mean when we speak of strategic litigation. First, we can say a few words about the terminology we are using. When we speak of strategic litigation, we are not solely focusing on court action, but also other means of dispute resolution and non-judicial means of redress, such as complaints, petitions, and the use of ombudspersons. In this series of modules, we are going to focus on what mechanisms exist in the EU. Strategic litigation, which is sometimes also called impact litigation, involves selecting and bringing a case before the courts and other dispute resolution bodies with the goal of creating broader changes in law and policy. The objective in engaging in strategic litigation is to make use of the law to leave a lasting impression beyond only winning the case at hand. While a strategic litigation case focuses on a specific issue, this kind of case is as much concerned with the impact that it will have on society and government as it is with the end result of the individual case itself. In strategic litigation cases, the public interest in bringing the case will usually be significantly more important than the facts of the individual case itself. The expected end result of the case will often have a significant impact that goes far beyond the individual benefit which is achieved for the party concerned. Strategic litigation is important in several ways. When it is successfully used, strategic litigation can bring about groundbreaking results. It can push a government into taking action to provide basic care for its citizens, guarantee the equal rights of minorities, or halt an environmentally damaging activity. There are no set limits as to what strategic litigation can accomplish. In the field of EU citizens' rights, it is one of the most important ways of defending the rights of mobile EU citizens experiencing destitution, because it can achieve lasting change which can have repercussions throughout the 27 EU member states. It can be used to expand the range of advocacy efforts, which are made by organisations that work in providing support and assistance to persons who are affected by homelessness. It also encourages a rights-based approach to achieving change in law and policy. There are several ways in which organisations that work with persons who are affected by homelessness can get involved in strategic litigation. Organisations can help identify cases that could form the subject of strategic litigation. They are in close contact with the affected individuals and will be able to piece together their residence history. Organisations can connect affected individuals with specialist lawyers who could then take on their case. They can act as a bridge between the two. Organisations can also lend their support to the affected individuals throughout the process. They've often carefully built up a relationship of trust with the individuals concerned. Strategic litigation is often part of a broader concerted advocacy campaign, which is designed to raise awareness of a particular issue or to take action to protect the rights of a disadvantaged population. Many groups or individuals who engage in bringing strategic litigation do so as part of a way to influence the government to change its law and policy and to seek to convince others to join their cause. In order to maximize the likelihood of legal or political change, any strategic litigation process will often be accompanied by other targeted advocacy efforts. Advocacy can broadly be defined as the efforts of individuals who come together in an organized manner in order to influence the formulation and implementation of public policies through persuasion and pressure. These activities are aimed at gaining access to and influence over people who have decision-making powers over a particular issue, or in matters which are of importance for a specific population group or for society in general. Advocacy therefore aims to achieve a specific outcome from decision makers. Advocacy efforts need to be systematic and strategic in order to achieve their intended objective. It is therefore important to allocate human, material, and economic resources to support strong political advocacy actions. Creativity and persistence are also needed, and celebrating victories, as well as learning from mistakes, given that failures are bound to happen as well. Strategic litigation represents just one form of action in the advocacy toolbox. Advocacy can take different forms, from putting out press releases, to organizing conferences and roundtables, to more creative actions, such as setting up exhibitions or performing a theatre play, or delivering and distributing pamphlets. These actions can be aimed at local, regional, or national level, as well as aiming to influence European institutions. For inspiration, you can also refer to Advocacy and Strategic Litigation on Housing Rights in Europe, a handbook for practitioners and NGOs, published by Housing Rights Watch. A link to this handbook can be found in the list of useful links included below this video. When engaging in strategic litigation, there are several factors to consider. The first factor to consider relates to the selection of your case for strategic litigation. This may require quite extensive pre-litigation research. This can include identifying areas of non-compliance with EU law. FEANTSA has produced a number of fitness checks on EU residence rights, covering several EU countries, and a link to these can be found below this video. Evidence can also be gathered from other affected individuals, or by compiling statistics or identifying case studies. Alternatively, there may be pre-existing research or evidence which has already been published. It may also be necessary, in some cases, to secure the support of other organizations, particularly those which may assist in engaging in complementary advocacy efforts. The second factor to consider is to identify the mode of strategic litigation which will be used. The third factor to consider are timescales and deadlines. Is there a deadline to challenge a refusal decision? Usually this is quite short, often a matter of a few weeks. Is there an election looming which could result in a change in political leadership? Is there some other foreseeable event which may divert the attention of decision makers? The final factor to consider is whether there may be other means of influence which can be deployed to achieve the same result. This links back to identifying complementary advocacy efforts which can be used alongside strategic litigation. You will find further useful links posted below this video. This concludes our first module, which sought to provide an introduction to strategic litigation. We hope you found it useful.